In this case, the process server reports available in the record shows that notices were issued and served on 3 occasions. Second point urged was that the notice mentions that the petitioner had entered into India between 1/1/66 and 25/3/71. This would have no meaning because of the provision of Section 2A of the Foreigners Act. Here we have dealt with Section 6A of the Citizenship Act. Third submission was that in the form of inquiry, the year of birth is 1965. This we have dealt with. And it is held that the entry made in column number 4 does not establish that he is a citizen of India by descent. Because in the form it has been disclosed that this is as per your disclosure. So it's not a observation of the finding of the inquiry officer. Accordingly, the writ petition is dismissed. Consequences of the opinion shall follow.
Home admission list, item number 1.
Well, it's along with the main PIL, IA is also listed today. Should we address PIL or IA first?
It's your choice. You are
IA,
the
is,
learned counsel. You'll have to.
IA has been filed by the respondent in the main PIL.
Yes.
My lord, on the last occasion, the matter was taken up on the last occasion, my lord, when this honorable court was pleased to observe that the maintainability of the PIL will also be taken up along with the hearing.
Okay.
So let us take the issue of maintainability first, whether the PIL is at all maintainable.
That's what our thought was also there. How in tender matters a PIL would be maintainable? What does the government do? If a tenderer is aggrieved, he will come. At whose interest you are there here?
My lords, with great responsibility, we are not into a particular tender item. We have not challenged any tender outcome or any tender that has been scheduled in the past. Why we are
you
here?
see, you have not even said here that how do you gain, or what is the interest it would serve?
My lords, it has been mentioned in the PIL also, my lords. What we are here before your lordship is to challenge the rules that has been framed by the state that has to be adhered in all the tender procurement process. So we are challenging the rule that is against the public interest. We are not challenging any outcome
In
of
tender,
a...
there is no public interest.
My lords, let me show to you that, my lord, your lordship.
It was a notification, my lord, not the rule.
My lords, may refer to page 31, annexure 4.
31.
31, my lords, of the main PIL. My lords, that's a notification that has been issued by the Finance Department, my lords. My lords, this notification states that any authority who will publish the tender, there will be a capping of 5% lower the estimate cost. So, my lord, because of this capping of lower 5%, all the bidders who are participating in the tender, they are forced to comply with this notification, and the amount financial quotation that they can quote is restricted to less than 5% of the estimated cost. So, my lord, what is happening? For example, there has been tender quoted and the estimated cost of work is, let's say, 100 crores. Now, all the bidder who are participating, they are restricted to quote up to 95 crores only. They cannot go beyond that. If they quote beyond that, their bids are declared unresponsive. So, my lord, what is happening with this notification is that there has been a substantial amount of loss to the public exchequer. If it would have been a completely open and fair tender, the bidder would have quoted maybe 20%, 30% or 40% less. That's the general how the bidder quotes. But because of this restriction that has been imposed to this notification, there has been a restricted of 5%. And that is causing a great loss to the public exchequer. That's the public interest involved in this PIL, my lords.
You see, today morning when I wanted to have a breakfast, I in the morning gave 50 rupees to my staff. I told him, get me an apple within the range of 40 to 50, not more than that. So he has got me an apple of a range of 40 to 50. What is so public interest is hampered when I ask him to buy us something between this amount to this amount?
Let me address with this example, my lords. My lords has given 50 rupees to buy an apple. So the market is saying that there are multiple sellers who are giving same quality of apple. One say my cost is 20, 30, 40, 50. But because of the restriction of your lordship that they has to buy apple from 40 to 50 rupees, there has been a loss of 20 to 30 rupees because there are other sellers who are selling the same quality of apple at a lesser price. So what is the stake is a public money, my lords. And my lords, how it would be called a fair and open tender? There are multiple bidders who are open to quote less than 5% also. But they are being restricted to
They
quote.
will come if they are aggrieved. How it is public interest?
Because, my lords, it's in the interest of the bidder only. Why they will come? For example, I am getting a work at 95 crore. It would have been an open tender.
This has come at the in respect of which tender?
No tender. It's, my lords, we are challenging the
Which-
state rule. No particular tender has been challenged. If we would have been challenged a particular tender, we would have come through a writ petition. We cannot go through PIL, my lords. My lords, the subject doesn't end there, my lords. My lord, may please, what's the next step? My lords, let me take you to the next step, my lords, which is at page 15. My lords, may come to page 32. So 5.
60% can able to expansion negotiation process. Policy decision.
We are just asking the Advocate General. You see,
My lord.
There are judgments of the Supreme Court, even the latest one, where it says that if the price bidding has a variable range, then that must be notified before the tender, before the date of submission of tender. Which is that judgment?
So the notification is already before the date of submission of the tender.
No, it's not a question of notification. There is a Supreme Court judgment which says that if you are having the price bid either positive or negative, that variable price,
My lord.
the price limit of the tender must be announced before the submission of date of tender. Which is that judgment?
Yes, that is being done. My lord, I'll come to the
No,
merits.
I'm not on that. I'm just want that judgment.
I will come on merits, my lord.
No, merit is something else. We are just wanting a judgment.
Regarding
The Supreme Court says that if tenders are submitted, before the date of submission of tender, if you are giving a variable value, then that should be announced before the submission of tender. So, which is that judgment? There are 3 judgments on the field.
so my lord wants to go through those.
First, I want one judgment because I am forgetting it.
And 5%, beyond that, they are declared unresponsive. Now, my lords, let's see what is the next step. If there are multiple bidders, they know that we can quote less than 5%. Everybody wants to be L1, they will quote 95. For example, if there's a 100 crore tender, everybody will quote 95 crores. My lords. So now, who will be selected among those 95? Let's see what the state has done with that respect, my lords. My lord, at page number 32, I would like to refer page 32. That's the next step what the state has taken. They have issued their own standard bidding document that has to be adhered by all the tender issuing authority. Well, let's may refer to page 59. That's the internal page of the state SPD members. Page 59.
Yes.
This tells how the selection process will happen if there are multiple L1 bidder mandates. Melons, first of all, I would like to address that on the top of it, it says Government of India Central PWD. It shows that it is a rules that has been followed by the central government and the state has just incorporated and following the state rules, or central rule, my lords. My lords, point number 4 tells if there are multiple L1 bidder, what will be the process? In case of lower tenderer amount, work out on the basis of the quoted rate of individual item of 2 or more bidder is same. Then the successful bidder among such bidder shall be decided by the competent authority. So now the state also has a discretionary power to select upon multiple L1. So my lord, what the whole narrative of the tender outcome is being controlled by the state. At first instance, how much the quotation amount will be, it's already controlled by 5% limitation. Now definitely there were multiple L1 bidders. Now who will be selected? There is no criteria. State has given themselves a discretionary power that we will decide and choose whom to award the work, my lords. Now, my lords, this on the top of the head, it says Government of India Central Public Work Department. My lords, I would like to take you, how does the true copy of Central PWD Department look?
That is on merit. This is not maintainability.
So, my lords, I'm just showing you how the public interest is involved. Public interest is involved because the 5% notification is causing great loss to the public exchequer, my lords. Second of all, a discretionary power that has been vested upon the state, that we will choose among the multiple L1 who will be the one. So that's again the whole narrative of the tender.
Is it your case that there cannot be any upper and lower this thing? It's 5% below and 10% above. Is it your case that there should be no ceiling of such?
No such ceiling, my lords.
There should be no such ceiling.
No such ceiling.
That cannot be. That cannot be. Now the state decides that estimates that a certain project or a certain material should cost around 1 lakh.
Absolutely.
Someone offers it at 100 rupees. Right? Now, if we go by your proposition, even he has to be considered because there is no lower limit to it. So how does the state define that our estimate being this, below this it cannot be? the material or the project work will suffer. Above this is not called for. There has to be a certain limit on either of the two sides. Tomorrow, if we ask you to buy a car for rupees 100 or rupees 1000, you would have your own doubts, you would walk out of it.
Now, there is a supplementary question to what my
So
esteemed-
now, would we be the persons who would stand up to say that the limit can be fixed by us, or has it to be fixed on a tender, on a work-based estimation by experts who know their work?
There is a supplementary question. Do you have an experience of constructing a house or a office or a furnitures in your office or your residence? Has it happened that the estimate which you have been told, at that estimate you have been able to successfully build it? You have been.
Malats, to respectfully to state that, for example, whenever the tender is floated, there is an estimated cost of work. Now, this estimated cost of work is usually the maximum. So now the bidders are invited to quote their own rates depending upon how they can successfully execute this work. A bidder might quote 95, some may quote 90, some may quote 85.
So according to the experts who are handling the entire tender matter, if something below 95 is not worth a consideration because there might be an issue of compromise, therefore, below 95 we do not consider. Are we the persons to tell them, no, keep it open-ended, no, keep it at 85, no? Or if 95 is bad, who are you to tell us, or the department, that it should be this? Would you have an expertise in every?
Malats is absolutely correct in this aspect.
What is your qualification of the petitioner?
He's a retired PWD engineer, Malats.
He is a retired PWD engineer.
Yes. Malats, with respect to that, let me address how all over India, even the central, address this issue. How much the limitation
You
of
forget it, the state is the owner. State will decide at what amount it is to be purchased.
Then, my lords, let us refer to what does the state passed legislature rule says on this aspect, my lords. Obviously, the finance department can issue their own rules, but can they violate their own act and rule passed by the legislature? Let's address to that issue, my lords, in that perspective.
That is for the government to. So if their departmental officers violate it, they are the employers. They will take a disciplinary action against the persons.
No, my lords, this is a state issued notification. It cannot be in violation to the act passed by the legislature. So whenever that happens, we obviously come to your lordship to challenge any of the notification passed by the state. So my lords, let me address on both perspective. How does this lower capping is being addressed by the central or the state of the other bodies, and what does the state passed legislature says with respect to capping? This is the state passed Mizoram Procurement Rules 2020, my lords. My lords, at internal page number 5, the fundamental principle of public procurement. My lords, the first point says that the state government considered it necessary that every procuring authority shall have the responsibility and accountability to ensure efficiency, economy, transparency in the matter relating to procurement, and for the fair and equitable treatment to the bidders, promotion of competition in the public procurement, and mechanism to prevent corrupt practices. My lords, the second says, it's very important, the procuring authority shall strive to get the best value for money and maintain the standard of financial propriety for the procurement. Well, it's to strive to get the best value for money cannot be attained if there are limited restrictions to quote not lesser than 5%. The bidder should be open to quote as much as they want to maintain the standard of the work that is supposed to be prescribed in the tender. So
That would be like saying that for a government job, there should not be any basic qualification. Anybody and every, suppose you want graduates and you want to say that graduates with 55% needs to apply. You would come here to say that no, graduate with 41% should also be allowed to apply. It is upon the department, it is upon the experts to determine as to what could be the mode and manner of limiting the number of eligible persons that we can consider, of finding out what is the number of, what is the baseline that we can adhere to. It is for experts.
So, my lord, I've just referred to the rule, what does Mizoram procurement rule says. Now I will address to the issue of capping, how it is being addressed.
Yes, Court Master.
My lord, this is a manual for procurement of work. I would like to refer internal page 78, my lords.
78.
To address that specific issue about capping, my lords, consideration of abnormally low bid. That was the issue my lords has raised, my lords. An abnormally low bid is the one in which the bid price in combination with the other element of the bid appears so low that it raises a material concern as to the capability of the bidder to perform the contract at an offer price. Procuring entity may in such cases seek written clarification from the bidder, including detailed price analysis of the bid price in relation to scope, schedule, resource mobilization, allocation of risk and responsibility, and any other requirement of the bid document. If after evaluating the price analysis, procuring authority determines that the bidder has substantially fails to demonstrate its capability to deliver the contract at the offered price, the procuring entity may reject the bid/proposal. Next is very important, my lords. However, it would not be advisable to fix a normative percentage below the estimated cost, which would automatically be considered as an abnormally low bid.
It is for the department to decide. Experts to decide.
And my lords,
These are
I
all
would
means. These are all means the department may do this. It's just a guideline.
so my lords, the capping can be there that this much be considered a normal abnormal bid. How the procedure happens is that, for example, the state say up to 5% lower is a normal bid. If the bidder should be remain open to quote less than 5%, but they should be, for example, the other state and the central body, what does they do?
Where is the statement? If the petitioner is a retired PWD engineer, please tell us where is the statement here that during his tenure, no tenders were floated having a price cap.
My lords, he was retired in 2022 and 24.
Whatever be, even at that time it was there.
My
The
lords,
variable ranges were given. Show us a statement that during his tenure he never approved it.
my lords, the outcome of any past tender we are not challenging here, my lords. My lords, we are just challenging the rules.
That is why he is the only person who is the correct person on earth. All others are inferior to him. We can't substitute ourselves to be an expert to say at what price something has to be procured.
Then, my lords,
And
even
in your writ petition, you say that the notification impugned and the standard bidding documents are the consequence of a policy decision. Unless you say that there was something wrong in the manner in which the policy decision came about, should we interfere with the decision of the state? Is that the law that we can decide, we can interfere with the policy decision of the state, saying that no, this is not a correct policy?
my lords, the 2G spectrum case is a landmark judgment. And the issue with respect to 2G spectrum also involve whether the court can intervene in a policy making decision. So, my lords, I would like
In a
to,
tender process, in a PIL.
my lords,
It's
that,
not a position, there's not a policy decision, ipso facto which affects the society.
my lords, we are
It
not.
affects, it affects contractors. If you are speaking of a contract of more than 100 crores, there will be only not more than 1% of the population in the state of state of Mizoram would be in a capacity to participate. No public interest.
My lords, it's not about we are not representing the bidder community, my lords. My lords, we are representing the public. Every tender issued, for example, if a 100 crore tender is issued and there is a limitation of 5% gap.
Sorry, it's a wastage of time. We are not interested.
My lords, may please at least allow me one more day to address the issue. I will refer to a relevant Supreme Court judgment also.
Please make it, summarize your submission and give it. We give you 10 minutes, 15 minutes more. You summarize it and complete.
Can it be relisted tomorrow, my lords?
No. We don't have time for this PIL. As it is only related to tenders. Had it been something which were of the condition of poor people, the food availability, the housing problem of the people, the what you call the natural calamities, we would have heard it daily.
But my
We have time for PIL, but in those cases where the public at large are genuinely affected, health issues, if those are there, pandemic, will
lords,
definitely take up
the
day-to-day
losses of
basis.
public money eventually in the end. If anything is getting lost in the hands of bidder, that is coming out of the state.
15 minutes you have. We will close it in 15 minutes. You can summarize. We will not ask you any questions. Make your submissions and complete it within 15 minutes.
Well, my respectful submission is that the notification 15 July 2024 restricting a lower capping of 5% is what it is causing. It's causing to eliminate a fair price discovery of every tender that has been published. Now there is an artificial tie cap also it is causing, and it is against the spirit of competition.
That is at page 31.
Page 31, my lords.
Yes.
Thereafter, my lords, at page 59, a selection process has been prescribed. It says if there are multiple L1, then
Where is the notification that the Indian Central Public Works Department manual is followed by the Mizoram, state of Mizoram?
my lord, there is no such notification. What I am implying to show through this is, my lords may refer page 89 and compare this page 59 with 89, my lords. 88, my lord, 88. My lord, this is a true copy of Central Government of India Central PWD Department. What the state has done, they have
Please come the page number again.
page number 88.
88.
And my lords may compare this with 59 also. This will reflect what the state has done. My lords. They have fabricated the Government of India's Central PWD guidelines. Point number 4 states it's copy paste. Only editable point is point number 4. Even the header says that it is a Government of India PWD rules. So the point 4 prescribes how the tender selection process has been incorporated. So my lords, I'll give a crux of it. It says if there are multiple L1 in a tender, then the tendering issuing authority will recall the multiple L1 to revise their bid in a second stage. Even in the second stage also, if there are multiple L1, then the next process will be a draw of lot. That's the procedure prescribed in the true copy of central PWD guidelines. Now, what the state has done at the first stage, it has given a lower capping, which amounts to that there will be a multiple bidder or all the bidder quoting less than 5%, and everybody will be L1. Thereafter, to even control the narrative, they have fabricated the Government of India's central PWD guidelines of the selection process. And they have incorporated the same in the state issued SBD, reflecting it as a true copy of central document. This was done only to control the narrative of the outcome. So what is the actual scenario of the any competition through a tender is that everybody knows what is a L1. So everybody will be L1. At the second stage, when the selection happens, state has given them a discretionary power. There is no procedure. We will decide whomever we want to give the work. So the whole narrative of the tender is being controlled by the state now, at the price quotation and at the selection stage. So is a fair tender is actually happening in the state of Mizoram? I respectfully submit, my lords, no. The whole narrative is being controlled. And that too by fabricating a central rule, representing as a true rule of the central PWD. Now, my lords, what I am referring to is Mizoram Transparency in Public Procurement Act 2008. My lords, I would like to take your lordship to internal page number 6, power to make rules.
Just a moment. Yes, please proceed.
My lords, I was referring to Mizoram Transparency in Public Procurement Act 2008. My lords, internal page number 6, my lords. Rule 25, power to make rule. The government may by notification make such rule as are necessary for carrying out the purpose of this act. Second, my lords, every rule made under this act shall, as soon as possible, after it is made or issued, be laid before the House of Mizoram Legislature for a period of 30 days, which may be comprised in one or more sessions. So, my lords, the notification of 5% capping has never been tabled also, as per what the Act procedures prescribe, my lords. Now, my lords, I would like to refer to the circular that I have just handed over.
Yes.
It shows how before the procedure with respect to capping was being handled. Well, let's point number 1, bid for PMGSY work in Mizoram with a variation of more than 5% below the estimated tender amount shall be treated as unbalanced bid. But there is still an opportunity with the bidder, my lord. The additional performance security to be deposited by the successful bidder for the unbalanced bid and shall be the difference between 5% below the estimated tender amount and the contractor quoted amount. The additional performance security shall be in the form of fixed deposit issued by the schedule bank. The period. So, my lords, there has been a capping of 5%, but that does not restrict a bidder to quote whatever amount he or she wants to quote. It has been declared as unreasonable, and the bidder are requested to submit additional performance guarantee to keep the state safe.
Yes.
Well, this judgment central for PIL and others. It's with respect to 2G spectrum case. So, my lords, I'll just take you directly, your lordship, to the most relevant para out of this. Page 91, para 79, my lords. This also pertains about a state policy where they have been distributing the license of the 2G spectrum as per the policy guidelines, my lords. Para 79, my lords, at page 91. In majority of judgment, my lords, has it? Page 91, para 79. It's the third or fourth last page, my lords. 79. In majority of judgment relied upon by the learned Attorney General and learned counsel for the respondent, it has been held that the power of judicial review should be exercised with great care and circumspection, and the court should not ordinarily interfere with the policy decision of the government in financial matter. There cannot be any quarrel with the proposition that the court cannot substitute its own opinion for the opinion by the expert in particular field, and due respect should be given to the wisdom of those who are entrusted with the task of framing the policy. We are also conscious of the fact that the court should not interfere with the fiscal policy of the state. Well, that's the next point. However, when it is clearly demonstrated that the policy framed by the state or its agency instrumentality and or its implementation is contrary to public interest or is violative of the constitutional principle, it is a duty of the court to exercise its jurisdiction in larger public interest and reject the stock plea of the state that scope of judicial review should not be
This,
exercised.
I believe, is the that 2G and 3G.
Yes, ma'am.
This was the policy of what you call first come first serve basis,
Yes, ma'am.
and the cost of the spectrum is how much we don't know,
Prior.
in thousands of crores.
Yes, it was very less as per 6-7 years before.
So is so that issue can it be equated with one of the tender where the bidders are participating?
My lords, we are not challenging any tender outcome. We are challenging
That's
the
why
rules, my lords.
in this case, it was the 2G and 3G spectrum, which was the auction condition was that this should be given in first come first serve basis.
Yes.
So he said that the other one, if it they had no choice but to work out.
Yes.
So that is not in public interest.
So, my lords, the selection process here is also giving a discretionary power to the state without any procedure. Like we can decide, pick and choose anyone among the L1.
It is only when there will be 2 or 3 L1s or 2 or 3 other persons who want to participate and want to know as to which of us would be selected, that the government would be required to answer. The answer not being satisfactory, they would have their own grievance before this court. In every case where a particular selection procedure or a particular manner has not been laid down, it will become a matter of public interest. Once we are only trying to envisage a situation that yes, maybe there will be 2 or more L1s, maybe there needs to be circumstances where choice has to be made.
Absolutely.
And in that circumstances, because there is a discretion, they will not act properly.
So, my lords, with respect to the selection process, it may not be in a public interest. But, my lords, the rule that specify the lower 5% capping, that is deriving to the public interest.
That was there in the year 2007. That rule was there in the year 2007.
No, man.
Yes. Please have page 27. It is your petition.
That 5% capping.
Yes.
My lords, that was there, but that has been again set aside by the
That
court.
was not set aside. That was withdrawn because at that point of time the policy decision was CPWD manual says we won't have it, so we are just removing it for the time being. Now the state decides that no, beyond CPWD we need it here. Why should we?
But, my lord, that cannot be in violation.
It was there in the year 2007 to 2013.
Yes, it was there
You
again.
were still there.
Yes.
You were still there. You
In
knew
office.
this position.
My lord, that I have to ask them.
All the
You were
persons
there in
were-
office.
Sorry?
You were there in office.
Yes, that time I was in the office. So,
So
my lord,
that time you did not see the malady because you were the authority on the point. Then you know how to proceed.
my lord, even that time, whenever the imposition of 5% restriction was there, later on, every time it has been set aside by some or the other way.
That is not your case before us.
No, my lord, that's not
That
our
is
case.
that is because you have raised a question on that issue. Whatever happened between 2007 to 2013, that capping part, no one had a grievance. You were not before this court. You let it go on happening. You knew you were at the helm of affairs. You knew about it. It did not strike your conscience at that point of time. Now you are retired. Now it strikes you.
So, my lords, with respect to that, if the state has the power to impose 5% capping, can it be in violation of the articles of the Constitution of
Can
India?
it be that we are to decide what is the capping?
No, my lords.
Then
My lords, I am not saying for
who
the...
decide?
My lords, they decide the capping of 5%. But, my lord, they cannot...
Let us see, we do it 100%. The contract price is 100 crores. Somebody may quote 0 rupees and he will get it.
My lords, how...
Are we the authority to decide that?
So, my lords, there is a criteria for balanced and unbalanced.
You forget it. Now we are in your PIL, we are saying that there will be no cap. That means even a person who gives a tender of 0 rupees will be able to participate. That is in public interest, according to you.
My lords, but who will take the responsibility of doing free of cost work of 100 crores? My lords, if somebody quotes...
There will be somebody who the government knows how to identify the person and to take care of that. What in this society which is governed by the rule of law, everything is very certain.
But my lords, with due respect, the 5% capping eliminates the whole competition. And what is at stake is a public money, my lords. My lords, for example,
How much tax do you pay to worry about that? How much income tax do you pay? You are exempted.
I am not for myself here, my lords.
So that's why you are saying don't worry about the public interest. There's no contribution for you to the state.
My lords, I am also a retired public officer. I have done my duty. I'm
Who
in a
was at the helm of affairs when this 5% capping existed?
sorry, my lord.
When this 5% capping existed in the year 2007 to 2013, you were there, you knew about it.
Be-
What steps were taken to protect public interest at that point of time?
My lords,
Now that the urge has come up?
I have not gone to
Then
the
it
court.
was only private interest. Then there was no public interest.
My lord, I was holding a official position that time, my
Sorry,
lords.
that's over. You're not interested. Your time is up. Yes, the Advocate General.
My lord, before I go into the merits of the case, if I can place before your lordships the rights. Well, this is a compilation of guidelines to be followed for entertaining letters, petitions received in case of a PIL.
This is Guru Vayur.
My lord?
This is the judgment of Guru Vayur.
Yes, my lord.
Paragraph 50, I think.
Lordship, if I can take you, your lordship is aware of this judgment and the guideline. I would only like to point out before your lordship, the last page.
Yes.
Cases falling under the following categories will not be entertained as public interest litigation, and these may be returned to the petitioner or filed in the PIL cell as may be. Number 1 is landlord-tenant. Number 2 is service matter and those pertaining to pension and gratuity. Number 3, here I am, my lord, complaints against central/state government departments and local bodies, except those relating to item number 1 to 10. Item number 1 to 10 has categorically about the particular issues in which a PIL will lie against a state government or a central government. But here, my lord, it says complaints against central or state government departments and local bodies except those relating to item number 1 to 10. So, my lord, here nowhere there is even a whisper of tender. Nothing has been mentioned. And what is state government, my lord? Let us see what is state government.
Just a moment. Yes.
Now, my lord, the meaning of the word government. Let us have a look at it. From the legal point of view, may I read out? May I read out?
Yes.
From the legal point of view, government may be described. I can hand over the book to you. I can hand.
No, just give us a brief of what you are saying. We'll understand. You have already given us this
It's a Xerox
395.
copy. It's a Xerox copy from this. From the legal
Incidentally,
point of view,
incidentally, before government, in this book, the word described is gunda.
government may be described as the exercise of certain powers and performance of certain duties by public authorities or officers, together with certain private persons or corporations exercising public functions. The structure of the machinery of the government and the regulation of the power and duties which belong to different parts of this structure are defined by the law, which also prescribes to some extent the mode in which these powers are to be exercised or those duties are to be performed. Government generally connotes three estates, namely the legislature, the executive, and the judiciary. In a narrow sense, it connotes executive only. So, my lord, the entire executive. Now, here in this particular guideline, my lord, will say that it has been specifically stated that complaints against central state government departments and local bodies, except those relating to item numbers 1 to 10. So, my lord, it covers the entire government except those which are mentioned in item number 1 to 10. So, as far as this particular PIL is concerned, the issue relating to this particular PIL, it does not fall under the category of 1 to 10. That's my first submission. Lordship, I would also like to refer to one particular judgment, my lord. Paragraph 33. I'm sorry. It would be 31. Paragraph 31.
Yes.
Paragraph 31. The contention of the petitioner that in the present case there is no order or notification by the appropriate government, but only an order passed by the Security Exchange Board of India, SEBI, for short, under section 4.3, and therefore requirements of condition D to section 2, subsection H of the Act are not satisfied is not correct. The term appropriate government has been defined in section 2A, and the reason for incorporating the same said term in section 2H has been explained above. The object and purpose of using the term appropriate government is to clarify the appellate avenues before whom appeals will lie. It cannot be read to water down and read down the scope of the expression public authority as defined in 2H of the Act. Central government or state government refers to the executive power of the state and will include their manifestations in various forms. The terms central government and state government have to be read and interpreted broadly and not in a restricted manner. So, my lord, the issue which
What is sought to be conveyed by this?
my lords,
What is sought to be conveyed by this paragraph 31?
paragraph 31, my lord, it explains the broader term of the word government, the state government.
Okay.
And it clearly mentions that a central and a state government refers to the executive power of the state and will include their manifestation in various forms. So, irrespective of whether it is a policy matter regarding a tender or a notice inviting tender, everything is included in that. And if that is so, my lord, then as per this guideline of the Honorable Supreme Court, this PIL, this issue cannot be raised in the form of a PIL. If any tenderer or if any bidder is agreed with any particular tender, they are at liberty to come before this Honorable Court by way of filing a writ petition, but not by way of a PIL, my lord. It's a policy matter of the government. It has been decided by the experts that how this particular tender issue has been or will be dealt with. Now, my lord has very correctly pointed out that from 2007 to 2003, there was a capping. I have enclosed the notification, my lord, of 2007 in my affidavit in opposition, my lord. If my lord kindly comes to the affidavit in opposition filed on behalf of the state respondents number 1 to 3. Lordship may kindly come to page 28. No, I'm sorry. 26A. 26A page. Office memorandum dated 24th August 2007. Exactly what has been referred to by your lordship just now. In partial modification, may I proceed, madam?
Yes. Yes, please continue.
In partial modification to the office memorandum circulated by memo number so and so dated 31st of August 2005, the figure 5% appearing in the second paragraph of the memorandum is hereby replaced with 5% and the words taken up to 2 decimal points appearing in the same paragraph is also deleted. The second paragraph shall therefore be read. It is therefore notified herein that the permissible variation in the rates of award for work shall be 5% from the SOR prevailing at that time on the lower side and 10% on the higher side with immediate effect. So it was very much there, my lord. And your lordship has correctly pointed out that when the petitioner was in service, this was there. And this was not set aside by any court. Thereafter, my lord, if I can take your lordships to some other points which has been raised by my learned friend and which has been countered by the state in the affidavit in opposition. I'll come to the judgments later on. Paragraph 9, my lord, page 6. Page 6, paragraph 9. My lords have got it.
Yes, yes.
With regard to the statement made in paragraph 14A of the petition, I say that as the decision is to be taken by the competent authority in the best interest of the government, and reasons for selecting a contractor needs to be assigned, there is no scope of favoritism, nepotism, or corruption in the selection process of the bidder. That all central rules, herein, my lord, all central rules do not automatically apply to the state government. In a federal structure, state government has a liberty to modify and adopt any central rules subject to the administrative requirements and prevailing state policies as per the state of Mizoram adaptation of laws, order number 1 of 1987, and the state of Mizoram adaptation of laws, order number 2 of 1987. Therefore, CPWD guidelines does not apply in toto to the state government.
Yes, yes, it applies.
Lordship,
It applies.
well, in a federal structure, it can be amended, my lord. My lord will kindly come to Annexure K,
Yes.
my lord.
We have this with us. Qualify করে দিও।
Hence, attended to this notification. So, at that point of time, notification changes will be done.
So that amounts to notification. Perhaps you are right.
It was possible, I know.
Perhaps you are right.
My lord will kindly see page
My
28.
esteemed brother is accepting your submissions. It's
My
not
lord.
a judicial acceptance, but your submissions has been noted.
Here it says that the central PWD will be.
Lordship, 1976.
Ah,
Thereafter, my lord, this is the state of Mizoram adaptation of laws order 20th February 1987, my lord.
We have not
Lordship will
found
kindly
that.
come to page 28.
28. That we had missed it somehow.
28 of my affidavit in opposition.
Yes.
The state of Mizoram adaptation of laws order number 1 of 1987, the 20th February 1987. Whereas by subsection 2 of section 43 of the State of Mizoram Act 1986, for the purpose of facilitating the application of any law in relation to the state of Mizoram, the government of the state of Mizoram, as appropriate government, is empowered by order to make such adaptation and modification of the law, whether by way of repeal or amendment, as may be necessary or expedient. So, my lord, in a federal structure, the state has a liberty to adapt or modify as per its own requirement. That is my humble submission. my lord. Now, Lordship, with regard to the
Please get that back, that notification. Please continue.
But the true object and the effect of the policy is to ensure that realistic, sustainable, and transparent bidding in public procurement. Experience of the government, my lord, in public procurement has demonstrated that abnormally low bids sometimes causes loss to the state exchequer. My lord, how? Lordship will see that sometimes in order to get a particular contract, there is an abnormally low bid being quoted and the person gets the job. Thereafter, my lord, the experience of various departments is that in midway the work is stopped because they submit revised estimate for escalation of price. And in the midway that particular work is stopped, revised estimate is submitted, and again the price is quoted at
Well,
a high.
since the Advocate General is making a statement, we won't disagree. But please find out by using your office, even in the tenders where marginally higher price is quoted, there also this is the same policy in APWD everywhere.
Sometimes
Without-
during
without-
I agree with your lordship. Sometimes during the process of the work it happens, fellow. But at least there should be a realistic price.
Not in 100% tenders. Every high value tenders,
There has to be a realistic price, fellow. Sometimes it is abnormally low and sometimes it is high, extreme high.
no, we are not
So
commenting.
therefore, in order to keep a balance,
We are
this
not
capping has
commenting,
been
but
done.
we have got judicial experience, including PMGY roads, where the tenders are for 1 crore to 8 crores,
Lordship,
where we have dealt with tenders of more than 100 crores. The same thing. The
it happens.
price escalation is that is the
And moreover,
best
my
part
lord,
of every
moreover, my
contract.
lord, the quality of the work. Sometimes we have to compromise with the quality of the work. So in order to rectify all these defects, my lord, there is no harm in capping, my lord. Capping of price at 5% lower and 10% higher. What is the harm? How the petitioner is affected, my lord? How it is a PIL, how it is a public investigation. If any particular tenderer or bidder is affected, he can come by way of writ petition. And with regard to selection, my lord, it is the experts who are selecting. It is not for any layman to select. Suppose there is a tie, it is the experts who will consider the financial capability of the person, who will consider the background of the person, who will consider the experience of the person.
But if you are not explicitly telling the tenderers that this is the manner in which we would be selecting from the lowest bidders if there are more than one, is it not something where there is a possibility of a...
we will issue a memorandum to that particular effect. That this will be the procedure.
What do you say about his argument when he says that when you fix it at 5%, everybody knows that whoever quotes it at 5% below this thing, there is a chance that almost every tenderer will be a L1 tenderer, and you have to, by some means or other, depend upon that clause to say that you have the discretion to choose, and that is where the blue-eyed boy may get a chance.
I will address that
Or
particular issue.
we fall back to the movie Sholay, where everything is by toss.
But my lord, there is a transparent process. A transparent process will be followed. I can
No,
assure you.
toss is transparent. In cricket, we do it. It's most transparent. Two
But in
persons
that
are there, we
case-
toss it.
In that case, my lord, the selection of the competent bidder or the most capable bidder, that cannot be achieved, my lord. Because
No, but
the
there should be
purchaser,
some.
my lord,
You see, my esteemed brother is saying that there must be some policy. Otherwise, the other policy could be that you can do it by a toss. The other is that you have a criteria laid down. So there is clarity on the people as to how they will be evaluated.
Lordship, Lordship, the purchaser who is sitting at the head of the department, along with their officers, they are the experts. And it cannot be presumed that they are dishonest. Or they will be acting arbitrarily.
It is not about whether the decision would be correct or not, or honest or not. It is about the persons who face the selection at that point of time as L1 bidders. Do they know the criteria on which the selection could be made? Page 33 of your affidavit has said that you would be adopting the CPWD clause 4.
The criteria will be notified, my lord.
That is what page 33. Is it page 33? Have you notified that in page 33 is what I'm asking. The last paragraph.
Page 33.
Is it what you're trying to solve? Your additional, no, affidavit in opposition.
Additional.
No,
Affidavit in opposition.
Affidavit
page
in opposition.
33.
Page
Last
33,
paragraph,
yes.
what is it? He initiated the PIL that although the CPWD contains clause 4, which says this is how we will choose among the L1, your particular document did not do so. Page 33, last paragraph, is it the answer to his apprehension by saying that you are ready to follow clause 4 of the CPWD on which he relies? And does the state propose to rely upon clause 4 of the CPWD manual whenever there is a tie between L1 bidders? Clause 4 you would find at, I don't know, page 88 of the PIL. If that is the clause we are following, that is what is being followed in the CPWD on which he relies, then his second limb of argument goes. That there will be no transparency. If CPWD is transparent enough, Mizoram government follows it.
Page, my lord.
page 88 of the writ petition.
PIL.
My lord, here it is mentioned draw of lots.
What is said is his grievance was that while the CPWD manual says what is to be done in case of a tie, your document perhaps at page, it was the page, yes, at page 59 says it will be decided by the competent authority without laying down the norms, and that is where it deviated from the CPWD. Simple as that is where it deviated from the CPWD. That was his stand. Now with page 33 of your affidavit in opposition, you have said that in case of tie, we will follow CPWD, clause 4, whatever clause 4 is. It is not his case that clause 4 is not transparent enough, or rather it is his case that you are not following clause 4 like the CPWD. If you say that by page 33, the state government agrees to follow what is followed in the CPWD, the discretionary part would be taken care of because there is a certain procedure laid down. Either that procedure is challenged by someone aggrieved by the procedure or otherwise, but it would not stand in this PI. So is your page 33,
My lord,
last paragraph, the
my
answer
lord,
to his question?
my lord, let me submit.
In other words, that element of ipsi dixit must be by way of a rule of law.
Rule of law, yes, my lord, let me submit. Now, in this particular matter, my lord, whenever there is a draw of lots, first of all, my lord, I have shown your lordship that the state government can amend
No, but
as per the requirement.
the 33 refers to this.
30
Therefore,
33 refers to this, I agree to that. But, my lord, In case of a draw of lots, we have examined this, we have discussed this. There is a high possibility that incapable tenderers may be selected.
No, but when you once have page 33, the office memorandum says that you will follow 4. It would now be the stand of the government to say that no, we will not even follow 4, clause 4 of the CPWD. Page 33 has clear statement that clause 4 will be followed. He has no grievance if clause 4 is followed. He wants clause 4 to be followed. He has made an example of clause 4 that this is what is required to be followed.
It's a question of draw of lots, my lord. It's a question of draw of lots. But
And that is what the government commissioner secretary finance department says that we'll do. That is what he is saying. We will do that.
But there
And
is
he
a
is not
high
agreed by that. He has no grievance on that.
He has issued the office memorandum, my lord, but since there was an interim stay in this matter, we had no other option but to issue this.
Then
But
his grievance
later
that
on, my lord, it was considered.
Then in
Later
that
on,
case-
it was considered, my lord. And it was, my lord, it came to the, it was a matter of discussion, my lord, that this particular issue, if it is considered by way of clause 4, it may be detrimental to the interest of the state government.
No, you can't say that. You see, if he is talking of tenders which is 100 crores, we can't even count and calculate that. But assuming that a man who is in capacity to give a bid of 10 crores and more, you can't say that he is incompetent.
And how do you, he's correct in saying that yes, you do not have a mood. You have not made known on what basis you would be deciding from amongst the L1. Can it be left to discussion later?
My lords, we will issue a notification to that particular effect.
Have you done so?
We will do that. We will issue a notification to that
This is
particular
the
effect
notification.
as to how, in case of a tie, the
You have done
L1
that.
bidders will be.
You have done that by 26th of May 2026. You have placed it on record before this court that this is the process we follow. And from what is following from you now, sir, this court is apprehensive, at least I am apprehensive, that
Your
tomorrow
Lordship,
you will take a different stand. You will withdraw this and say that no, we do it
Your
because we
Lordship
like
is
it.
absolutely correct on that particular point, but my Lord will kindly appreciate that there are some practical difficulties, my Lord, when it goes to a draw of lot.
You see, you are an experienced
Because
authority.
incapable bidders, my lord, I'm again repeating, it might be a repetition, but incapable bidders, there is a high probability that they may be selected.
Once a person crosses the technical bid, he goes to the financial bid, he comes out as L1, and you are saying that one of them may be an incompetent. Then how does the court or even the state, not the state as such, but the others depend upon your decision to choose a particular man when you are not laying down the criteria even?
Lordship will allow me to refer to my additional.
Can I give you a very horrible example? You see, before us, a batch of lawyers are arguing. Everybody has an LLB degree. And then I presume that A who has stood up is incompetent without even hearing him. This man is whoever competes for tenders of 10 crores, 100 crores, is a registered contractor. So his competence was already decided by the either CPWD or by the Mizoram PWD that he is having a capability. He is registered as a class A, 1 class or something, X class, Y class contractor. The capability, you can't question.
I agree, my lord.
They will not say how they do it. They will pick anything. That will be the so now actually what 5% and what's about this. There is a chance that everybody will be 5% because it is a clear process. State government says how we would do it in case of the regulators. There is transparency, we have nothing to say. In this particular area, 5% or 10% of the but before
procedurally done in this question. This is the total discussion of unknown authorization. We don't know who's the particular. We don't know what is the process. Should we recommend? I don't know. I don't feel the detail. But the only computer is what happened. We don't know any adjustment. It will require a and to make the process particularly effective. We don't need to litigate. CPW to follow permission. That is the government policy. Depends on the nature of tender. Every time there is a tender, there is no definitely CPW after the process it can be implement the product. So CPW to is it go to option correspond? More than 40%. Excess
Which is that case? Is it the Ramansham or that airport authority where the Supreme Court did the auction? Which is that case? Ramansham.
We have not been able to trace it. We have not been able to trace it.
In this case, in that case, I forgot. I think Ramansham it should be. In that case, the Supreme Court took a view that the bidding was abnormally low, and it conducted in the open court the auction. And in that auction, the price, a good price was achieved. Because if this we are saying, because of the fact that if the government has a free hand with regard to the pick and choose policy in every tender without there being a policy, then definitely this PL would be entertainable. There can't be a discretion in high value tenders that you don't have a plan.
I agree to that, my lord. I agree to that. But if your lordship kindly permits me, let us have a look into page 33 again of my affidavit.
The only way to curtail this discretion, which is of a high value tender, is only when you give an undertaking as an advocate general that we will come out with a transparent policy where the bidders would be aware of the criteria of selection. Because you see, it was CPWD Manual 4. There you say that the draw of lots will bring some person who is incapable.
Lordship, that is why I want to draw your lordship's kind attention to page 33 again. My lord, may I be permitted to read it out? My lord, this was absolutely a temporary arrangement in view of the interim order which was passed.
That is our very apprehension. Our very apprehension that by adopting a temporary arrangement, an attempt is made to get the stay vacated, and no commitment is there before this court
my lord,
that this will be a permanent arrangement.
I am coming to that, man.
You see,
My lord, I am coming to that.
we'll tell you why this question is coming. We'll tell you something has happened. That's why we are telling you. You see, for example, I have a habit of writing with this pen. This is not the correct one, but this something like this. This is a pen. It has a refill. Now, according to our procurements, we say that we will purchase pen. This pen would otherwise cost rupees 100. It has a refill which can be given at 20 rupees. But this 20 rupees procurement we can't make. It says because this is not your set criteria. Therefore, you will be the stand of the competent authority in the government is that you purchase whatever is notified, you purchase a pen.
I agree, my lord. My lord will kindly
So
see
therefore,
that.
what could have been replaced by a 20 rupee refill is not being permitted. This is one. It's a very simple what you call problem we face. We are telling you. Supposing for an example in the toilet in the bar, there is a leakage. The PWD people will come and replace it, but there is no competent engineer in the entire department who knows how a faucet, washer can be replaced, and by 20 rupees washer it can be replaced. This talent is not there in the PWD. You can ask them. They don't know how to change the washer in a basin. They will replace it because the replacement tap is 20,000 rupees for a Jaguar set. That they are very happy to do it. This is something we are facing day in and day out. When it comes to the repairs and renewals of few things in the code, here and there.
Lordship, since the development works had to be stopped and further notice inviting tender could not be issued on the basis of this 5% and 10% capping, the state government issued this particular office memorandum. And my lords will kindly see that in the last paragraph, in the meantime, all procurement works shall be governed by the provisions of such. In the meantime, that is till until the final disposal of this particular PIL, we will work on that particular arrangement. It was absolutely a temporary arrangement for carrying on the development works. We had to stop all the works.
So now, since this court is expressing a view that leaving everything to the total discretion of a competent authority who is not named,
We will notify that, man. I am making a statement to that particular effect. That we will notify who will be the competent authority and how the competent authority.
with that, if you come back, it will
And
be
how the
another
competent
matter
authority
whether it should be a 10% or a 5% cutoff. That is another issue where we have our doubts whether we should be entering that arena or not. But once we have got 10 L1 bidders, whom we cannot say are whether interconnected or not, 10 L1 bidders, and the discretion is completely with an unnamed competent authority to choose at discretion who will get the job.
My lord,
That is something we think is against public interest.
we will fix up a criteria. We will notify that.
If you notify the competent authority, and like you have done at page 33, yes, Mr. Counsel, that at page 33, temporarily they have said we will do it in the manner it is being done in the CPWD. Your grievance was CPW has told how it is done, but the Mizoram government does not tell us. Yes? So now as a public figure, as a person trying to represent the public, if the Mizoram government says this is the manner in which it will be done, be it with the CPWD or be it in some other method, whatever they think deemed fit, that part of the grievance is solved, then someone will be selected on the basis of some criteria which is tangible, which we can yes, by a competent authority who is defined. Then the limitation of 5%, 10%, whatever, upper, lower ceiling, those are your prerogative. We don't intend to interfere. But this part of the thing,
We will
we are
notify
more
that.
concerned because what you start off as an interim arrangement, the CPWD part, there is no commitment from the state government saying that this is how we will do.
We will notify that particular part with regard to the competent authority and how it will be done.
How is this?
We will notify
The
that.
criteria, the criteria in which
Because in a lighter note, we were just discussing,
My lord.
in a lighter note, it's not a comment, but a lighter note. You see, experts made this page 33. This page 33 was devised by experts. And you disagree with that.
Lordship, that was in view of the. I agree to what the Lordship is saying, but my lord, it had to be done due to the interim order and due to the progress of the development works which were stayed. We had no other option but to adopt this particular rule. But I am giving an undertaking that we will notify the appropriate authority and the procedure.
We'll
of
just take a
selection
short break and come.
from
Give
among
us,
the L1 bidders.
we'll just take
We'll
a
do
short
that.
break and come back. 5 minutes.
My lords, my lords. And I will also place the CPWD manual, which mentions about the acceptance of the lowest tender and who are the competent authority and up to how much they can decide.
you just come back.
We'll just come back.
I'll take 10 more minutes.
Yes.
With regard to that particular part, I am giving an undertaking that constituent will be notified by the government with regard to selection in case there is multiple L1 bidders. And with regard to the entire procedure also. But, my lord, if I can place before your lordship Annexure 66 to the CPWD rules wherein the financial powers delegated to CPWD officers. My lord will kindly see the relevant page. Rule 17. My lord will come to 17. Annexure 66, 17. Acceptance of lowest tender after call of tenders with or without negotiation for both original and maintenance work. Now, my lord, kindly come to the right hand column. AE, AEE, ADH, 6 lakhs. That is the assistant engineer and so on. EE, DDH, executive engineer, 100 lakhs. SE means superintendent engineer, 10 crore. Chief engineer, 30 crore. ADG and so on. So they have been delegated with financial powers to decide with or without negotiation. This is as per the CPWD rule, madam. So if that is there, if the CPWD can rely on their officials, at least allow us,
This has to be read with clause 4.
my lords,
This has to be read with clause 4. The person who will sign the document who is competent enough is,
it has to be read, my lord, but
the procedure is there.
but the
in 4.
financial power,
He does not have the entire discretion to choose whomever he wants to.
but the financial power has been delegated.
Have it your way. You give it to you give your powers to persons whom you think are competent enough to handle.
And with regard to the competent authority, my lord, I am again submitting that the state government will notify
not
the entire procedure,
not the competent authority, the procedure and the manner in which it is to be done.
in which the selection will be made. And also the competent authority.
The criteria.
manner will be, that includes the competent authority. We'll do that, madam. We'll do that. But my lords will also consider the maintainability of the PIL, which I raised first. That was my first objection, that this PIL is not maintainable in this form.
You see,
And I have raised the guidelines also. of
there
the
lies
Supreme
one
Court.
difficulty. We wanted a transparent process from the PWD, and therefore we are just making known to you the transparency which is there in our thought process. You see, so far as in the high value tender, a discretion which is unfettered is not desirable. That's number one. And therefore, what we propose is that so far as for the present, there is a stay operating. Insofar as the stay is concerned, we say that for the time being, in view of page 33, you follow your procedure which is agreed to. This will lead to a situation where the PWD in a timely manner will come out with a notification identifying the process in which they want to do the other tenders. Once that is done, we close the PIL. But once we decide about the admissibility, then the matter goes in cold storage for a long time. Therefore, what we are proposing is that the matter will be put up on a date after 2 weeks or 3 weeks, as you suggest. In the meantime, with the stay which is operating is modified to the effect that you follow your page 33 and do it. And in the event you have different notification coming, you see it and then we close it. We don't say about anything.
But what about the interim stay, madam? We are unable to.
That's why what we are saying. For the time being, it's your page 33 notification. You follow that. And if the government goes by your opinion and they modify it to bring about more transparency, then you place it before us, we'll close the PIL. Therefore, we don't decide
We
the
will notify the
maintainability.
process of selection.
Yes,
We will notify the process of selection along with the competent authority.
then it's a matter of 1 week or 2 weeks or 3 weeks, whatever you desire. It is only for that. But there is some transparency, and therefore his PIL, instead of being dismissed, will be closed on the satisfaction. His point is only one, that there is no transparency. If that is addressed, we don't have to say anything.
We will notify that. My lord can record my statement.
For the time being, we are not referring
We
it.
will notify that.
This is what the court proposes to do is, you have given page 33 where you said that for the time being that 5 and 10% is not applicable to any fresh notice, and so if there are L1 bidders, clause 4 of the CPW would be followed. That is for the time being in view of the interim orders. Now we propose that in this IA we allow you to proceed with whatever tenders are now there with you, whatever you want to do. So far, the state government keeps itself bound to 26/5/2026, which is your own notification. In the meantime, within 2 weeks, if you come back with a fresh notification saying that this is the process we intend to follow, this is the notification fresh, which will be final, we consider it and we close it.
With regard to selection of L1 bidders and who will be the appropriate authorities.
So for the time being, the interim order will be modified, allowing you to proceed with work so long you adhere to page 33 of your affidavit in opposition.
With
And
liberty
until
to
the
you,
government comes up with a
with
fresh
liberty to
notification.
you, with liberty to you to modify your stand and then
With
bring it out.
with liberty to the state government
Uh-huh.
to modify
Yes, definitely.
the notification and clarify with regard to selection of L1 bidders and who will be the appropriate authority.
The moment you issue that and bring it before the court, we allow that and you can proceed with whatever you want.
But again in a PIL, my lord, again they will object to that.
To which?
Again the petitioner will object to that.
Our mind is very clear. Things which the experts should be handling will not be handled by us.
My lords,
Things which are supposed to be handled by experts will not be handled by us. But the transparency which is supposed to be there, which is there, otherwise in other state
that should
government
be
or central
reflected in
government,
the notification.
that should be there.
That should be reflected in the notification. My lord will
People
kindly
should
make
know.
it clear in the order.
People should know how they will be handled, how their cases will be handled. You might want PhDs for every post. We cannot object to that, but people should know that at least they have to be a PhD. After
My
everything
lord,
ends,
if my lord kindly allows me to place my additional affidavit, one particular judgment. There are several judgments which I have placed with regard to selection of L1 bidders, my lord. Lordship will kindly come to page 10. This is the Delhi High Court judgment. I have cited several judgments of the Supreme Court, wherein the state is the competent authority and the state has got rights to frame its own policy with regard to tender. But
You see, when
this
you are
is,
showing,
this is a matter, my lord.
when you are showing us page 1, this page 10 you are showing us. In page 10, you see only one line. It can be used to your detriment. The quotation, it is not the domain of the writ court to sit as an appellate authority over the decision taken by the tendering authority, and scope of interference being extremely low. Interference is warranted only in situations where the decision of the tendering authority is colored in malafide or was intended to favor someone, or it is so outrightly perverse that a reasonable person could not have arrived at such decision. Therefore,
Has the petitioner been able to establish that it is a clear case of malafide or there is a wrong intention on the part of the state government or there was a malafide intention on the part of the state government, or any arbitrary action on behalf of the state government.
In the absence of any criteria being laid down, there is a
Apprehension. Apprehension.
and at a stage when and when there is an apprehension of or possibility of biasness or arbitrariness, the courts can interfere, sir. And when in the complete absence of any criteria being laid down, if while
There's an apprehension, I agree.
while applying that criteria, you are a little bit arbitrary, we may not interfere because there is a criteria and you will not be able to establish it.
I agree,
Absence
sir.
of a criteria, how do we decide whether there is arbitrariness or not?
And thereafter, my lord, in page 11.
No,
My
you
lord
are-
will kindly come to page 11
No,
also.
you are missing two things. Number one, first we expressed to the learned counsel for the petitioner that we are not very interested. That is one part which was made loud and clear. Second part is apprehension which arises because you said that this is only temporary and therefore it can be revisited. So the apprehension is, will this revisitation come on case-to-case basis or you have a policy? Then you said
No,
that you will
be a
notify a
sir.
policy.
It will be a uniform policy.
So therefore, we don't need to decide anything in this PIR. Because the case of the petitioner is that there has to be some policy. And you are notifying the policy of your own, the matter stands closed. Why should we go into a issue of
Lordship, will kindly
maintainability?
record that. Kindly record that in the order.
Yes,
so
yes,
that-
yes.
So that things are absolutely clear and at subsequent stage, the petitioner cannot come again challenging that particular notification, that this is arbitrary notification. Because I wonder whether it is actually a public interest litigation or a personal interested litigation. I really wonder.
My court master will collect the names of the sitting counsel and yours. Heard so-and-so and counsel for the petitioner.
My lord, may I be permitted to leave my learned
Just it will
advocate?
take 5 minutes. It will just take not more than 5 minutes. Because if you need certain what you call additions in the order, we'll
Lordship,
definitely do it.
Lordship,
Full stop. Also heard Mr. Biswajit Deb, learned Advocate General for the state, assisted by so and so learned government advocates. Next para. The grievance of the petitioner is reflected in paragraph in the order dated 25/2026. And therefore the same is not reiterated herein. Where is that interim order? Next paragraph. From the submissions made by the learned counsel for the petitioner, comma, he has stressed on only one point, that in the event there are more than one lowest bidder, comma, no, there is no fixed criteria on the basis of which the successful bidder would be selected. Full stop. It is in the said context that the learned Advocate General, while maintaining his stand for the PIL to be not maintainable, has submitted that in view of the order of stay operating by the order dated 25/2026, the Government of Mizoram, Finance Department, Expenditure Control Branch has issued an office memorandum dated 26/5/2026, which is appended to the affidavit in opposition of the state respondent numbers 1 to 3, and it is submitted that for the time being, the provisions of clause 4 of the CPT manual would be followed until further instructions are issued. Full stop. It is submitted that the competent authorities in the government, in the appropriate government, are further finalizing, would further clarify the criteria for selection of bidders in the event there are more than one successful lowest bidder, so as to bring transparency in the selection process, and also to notify the authorities who would be the competent authority to have financial delegation for being the appropriate authority in the PWD. Correct?
Not only PWD, my lord, it concerns all other departments.
Okay. For the
PWD and other departments.
for the procuring departments.
Self-procuring.
Procuring department or engineering departments? What do you say?
Procuring and engineering departments.
Procuring and engineering department. No, because procuring will again have some difficulty. Procuring will be everyone.
Purchase.
Because even the High Court would be a procuring authority. So therefore, engineering authority means the irrigation, the PWD, or those engineering departments.
Make it engineering.
Engineering departments make it. Procuring, maybe all departments will be procuring something.
Engineering departments who intend to execute work on the basis of tenders.
At this. Engineering departments who execute works on the basis of tenders. Full stop. Next paragraph. In view of the said submissions of the learned Advocate General, the court is of the considered view that the issue that keeping the issue of maintainability of the PIL open, if the state government comes up with the selection criteria as indicated above, the grievance of the petitioner would be fully addressed and nothing more would remain in the PIL. Full stop. Next para. Accordingly, comma. The court is inclined to order as follows. Number one, that in view of the submissions made by the learned Advocate General, comma, insofar as the interim order dated 2026 is concerned, comma, the same be modified so as to enable the state to proceed with the tender works of the selection of the, what do you call, the tender process. However, comma, for the time being, until the policy of selection of lowest bidder, in the event there is more than one lowest bidder, as suggested by the learned Advocate General, is issued, or public notified, comma, the state would follow the office memorandum dated 26/5/2026 till then. Stop. Next one. Accordingly, liberty is granted to the state to bring further instructions, comma, if any, on the selection criteria. Next para.
My lord will kindly mention along with the appropriate authority.
Huh?
Along with the appropriate authority. Selection criteria
Appropriate
along
of
with
the
the
competent, along with appropriate competent authority. Next para. Next para. Next para is agreed to by both sides. List the matter again on.
Lordship will give us some time. 26th is a holiday. 27th of August.
We have on 27 division bench.
Yes,
We have a division bench on 27. I think it is 2nd September.
Second September, my lord, I am in Supreme Court. Any fixed date, my lord? There can be division bench. Today is the Thursday. So it can be.
No,
taken up.
this is done only because of the matter being fixed. It was not a.
My lords can fix the matter on any day.
Can we make it 25th?
Lordship, we'll make it.
There's a reason for that. 27th is sandwiched between two holidays. So there will be a lot of work pressure. 25th.
25th of August.
Yes.
And in event, my lord, the notification is issued, then the PIL will stand closed on that particular day.
That's why we have limited our words. We have said there is only one point raised. If that is there, then the grievance of the petitioner is addressed. We have stated that in the order. Okay. Just add, in the event any further notifications or office memorandums are issued, comma, liberty is granted to the state to make a mention for out of turn listing.
Twenty-fifth of August.
25th is there, but if you can come up early, then we give you liberty to
Mention it.
make a mention with information about to others.
With the notice to the other side. Deeply obliged.
Your Lordship's indulgence in mentioning part 2, item number 23 and 21, my lord.
Part 2 is not likely to reach today.
My lords,
Uh,
we're only seeking that it may be fixed for Tuesday, my lords.
Hmm?
It may be fixed for Tuesday, my lords.
On the
Or
18th, my
next week,
lords.
my lords.
No, because we still have time tomorrow.
My lords, my lords.
My lord, my senior is out of station, my lord. So if this may kindly be taken up on the 18th.
The thing is, my lords, it's a fixed matter for today. That's why.
Just pass what says the representative of the prayer made by learned counsel for the respondent, the matter stands adjourned today. List on Swenson.
18th, my lords.
Deeply obliged.
Right.
May I seek your Lordship indulgence in mentioning item number 13 from today's Lordship.
13.
Yes, Lordship. Although today is a fixed item, Lordship, my senior, the leading counsel, his son has been admitted and is admitted in the NICU hospital. So
Okay.
if the matter can be kindly
You,
taken up
you are
after
for
3
the
weeks.
you are for the appellant.
Yes, Lordship.
After 2 weeks.
Last time also they have prayed for adjournment, it can be fixed.
Pardon
By
me?
17, Lordship, it can be next week, Lordship, if possible.
If he is in hospital, you must give him time to recover.
I was informed that his daughter or
His
his
son,
son,
his
his
son.
son, not he himself. It is his son who is in hospital, not the council itself.
So next week.
I'm not sure about it. At the convenience of the court.
You see, we must be compassionate. If the son is hospitalized or family member is hospitalized, we should have some compassion.
Yes, Lordship.
Correct. Because if somebody is hospitalized, that means something serious. He may not like to, he may not be able to concentrate. Okay, both sides are represented. On the prayer made by learned counsel for the appellant, the matter stands adjourned today. Next list on. Give a date after in the next week. After a week, give a date in the second week.
21st of August.
Lordship, yesterday we have submitted this unlisted, but today it is listed in supplementary, Lordship. If it can be bring forward, Lordship, it is very, very urgent matter. Before
We'll take it up, don't worry. We'll take it up. Yes.
If it can be brought before hearing.
We'll take it up, don't worry, we'll take it up. Before rising, we'll take it up.
Lordship, I want to mention two repetition, unlisted matter. And yesterday you have filed the number of the petition also given. Kindly listed for tomorrow. Number is 114 and 115.
Okay.
Yes, my lord.
Basically, Lordship, in
I'll just address the bar. There is some issue, some problem which we are facing in the registry. I think we'll need your cooperation in the matter. In writ petitions where there are more than 20-30 respondents or petitioners, because of lack of adequate persons in the registry, they are finding it difficult to type it out and have it entered into the CI system. So I would request the learned counsel to give those in form of a pen drive, in the pen drive or by some means, so that it can be copied. It may, because even in copying a particular line for, say, supposing there are 20 respondents or 20 petitioners, it takes about 1 minute to copy it, paste it, and do it. So, because of the understaffing of the registry, I think we'll have a discussion with your members of your association, so that cooperation, if we receive, it will be easier for the registry to handle. So, I'm just making a oral request here. We'll formally make a request to the Bar Association. Okay.
Basically, Lordship, indulgence in mentioning item 11 of today's list, my lord. If it may be taken up on the first week of September, for admission hearing, my
You have
lord.
taken consent?
Yes, my
Is
lord.
there?
I have taken consent.
You are for the respondent,
I'm for the appellant, my lord.
appellant.
Yes.
Okay. Both sides are represented. On the prayer made by learned counsel for the appellant, matter stands adjourned today. List on
First week of September, that
okay,
is
1/9/2026.
deeply obliged.
Lordship, in item number 10, I'm for the appellant and my learned friend is for the applicant. So today is a fixed item of similar prayer, Lordship, after 2 weeks, if possible.
Which one?
Item number 10.
His senior son is in the NICU, my lord.
Huh?
Her senior son is in the NICU hospitalized.
Oh, acha, acha. Okay. Both sides are represented. On the prayer made by learned counsel for the appellant. You are the appellant.
Yes, Lordship.
The matter stands adjourned today. List on when?
After 2 weeks, if possible,
Give a date
Lordship.
after 2 weeks. Give a fixed date.
31st August.
Deeply obliged.
Obliged, my lord.
Lordship, I seek your indulgence on mentioning part 2, item number 22, which is also fixed for today.
Part 2 we may not list. We may not reach. It will go as leftover.
My lord, let the matter be fixed, given fixed date for item number 22.
It will be leftover. It will come otherwise also next week. This week it's not coming up
Okay, my lord.
because we have not yet reached any, we have not touched any item in part 2.
Okay, my lord.
Unlikely to reach.
Obliged, my lord.
Lordship, with regards to item number 12, part 1. Lordship,
Item
number 12, part 1.
12.
Lordship. Yes. Today list, my lord. The leading counsel, Mr. Johnny, has personal difficulty today, my lord. So,
This is 2012 matter. Is one of the oldest matter here in this court.
Lordship.
Your Lordship, if this matter can be taken up next week as a fixed item.
But this is fixed matter. And
Yes, Your Lordship.
2012 is one of the oldest cases here in the
Yes, Your
in
Lordship.
this court. Just wait. Let us see if we can get time. Just we look at it and then pass orders.
Your Lordship, the leading counsel is not present
No,
today.
whatever be the reason, but let the item be called first. In
Yes, Your
scheduled
Lordship.
course it comes, then we consider your prayer.
Daily list for admission, item number 1.
Lordship, in this case, in the IA, we have received the objection submitted by the respondents. However, Lordship, my prayer is still the same.
Just a moment. Where is the judgment and judgment and decree?
Judgment and decree is at annexure at the appeal. Memo, it's annex A1 to A30, my lord. Before the synopsis.
Just a moment.
Yes.
Yes.
Similar prayer, worship, for this, for the hearing on the IA of stay, worship.
Yes, we are taking that up. Who is for the respondent?
I'm for the
You are there.
respondent, Your Lordship.
Yes, what do you say?
This IA is a stay application, Your Lord, and from the reasons that have been offered by the applicant, there is no, they have failed to demonstrate the irreparable loss or any substantial harm and injury that could cause in the event of the execution of the decree. So their application is vague. It is not supported by any material evidence. So, and in fact, this stay of the judgment and order and decree would cause grave prejudice to me, since it would deprive me of reaping the benefits of the said judgment and order and decree. Your Lordship, this appeal arises out of a money suit in which the appellant herself, as defendant before the trial court in her cross-examination, she has accepted that there is a remaining balance of rupees 10 lakhs that has to be paid to me. She even admitted that in her cross-examination before the trial court. Now she has come and filed this appeal now, finding new grounds of appeal, and then she has filed this appeal. So, and along with this RFA, this stay application has been filed. So, and also this the appellant has also failed to offer any security or her willingness to comply with the mandatory provision under Order 41, Rule 5, Subclause 3 of CPC, that is the security to be deposited before the Honorable Court. So, in my humble opinion, this application is liable to be rejected.
Lordship.
Yes.
Yes, Lordship, for the a hearing on the stay, if the matter can be kindly taken up after a week, Lordship.
Stay
Yes, sir.
application. Stay application is immediate now. Now only we are taking it up.
Okay.
Because if we adjourn it, what do you call? There's no stay operating. There's no stay operating.
No, no stay operating.
So if you want an adjournment, we'll give you how much time you need? 6 months?
No, Lordship. A week,
Then?
Lordship. If possible, a week, Lordship.
No. This should not take. We should do no delay. We'll give a condition that within a week from today,
Yes, sir.
you will have to give a security of the decretal amount of rupees 10 lakh. And you'll have to disclose your assets. You file an affidavit and disclose your assets. If you fail to give security for the sum of decretal amount of rupees 10 lakh, or you do not file your affidavit of disclosing your assets, then the order would be vacated, the stay would be vacated on the next date. We find from the order that you have taken over possession of the land.
Yes, Your Lordship. She's in possession of the land.
Yes, sir.
We are giving you a stay which is conditional. Within a week, you will have to file it. The matter would be listed after 10 days, and in the meantime, you'll have to give security. Otherwise, if you don't give that security within the time period of 1 week, then stay would automatically be vacated without order of the court. Heard Ms. So-and-so, learned counsel for the applicant. Just have their names, huh? And so-and-so, learned counsel appearing for the respondent. This will be in the IA. Applicant and respondent. Next para, the applicant is the appellant in the connected appeal, which has been filed to assail the money decree for a sum of rupees 10 lakh with 12% interest by judgment order and decree dated 24/9/2025, passed by the learned civil judge, senior division -3, Aizawl, in money suit number 35 of 2021. Next para. This interrogatory application has been filed for stay of the execution of the decree. Next para. As a money decree has been passed in money suit number 35 of 2021, stay of the execution of the decree would be subject to conditions mentioned here and after. Next paragraph. The execution of the judgment and decree dated 24/9/2025, passed in money suit number 35 of 2021 by the learned civil judge within bracket senior division bracket +3 Aizawl, shall remain stayed subject to condition that within a week from the date of this order, the applicant shall furnish surety of a sum of rupees 10 lakh before the Court of Learned Civil Judge within bracket senior division number 3 Aizawl, which should be to the satisfaction of the said learned court. Full stop. Moreover, comma, next para, this is moreover, comma, apart from furnishing security, comma, the petitioner, sorry, the applicant shall file an affidavit to, in terms of to file an affidavit to disclose her assets which shall also be filed before the learned civil judge within bracket senior division bracket number 3 Aizawl. Next, by the said learned court on being furnished with the surety as well as disclosure affidavit. Shall record the same in the in a supplementary order sheet of the of money suit number 35 of 2021. Decree, the what you call the execution has been filed. No.
Yes, Lordship. Execution has been filed after notice was issued in the stay.
Okay. What is the number of the execution case? You see that it will be filed in in connection with the proceedings of money execution case number.
Lordship, if I can bear with me for a second. Execution case number 171 of 2026. 171 of 2026.
2026.
Yes, Lordship.
Which has been instituted before the court of learned civil judge within bracket senior division number 3 Aizawl. Next para, the applicant is put to notice that in the event the aforesaid two conditions are not complied with, comma, the instant stay would stand vacated without any reference to the to any further orders of this court, and it would be open to the learned civil judge within bracket senior division bracket number 3 Aizawl to proceed with the execution. Next paragraph. With the conditional stay as indicated above, comma, this interlocutory application stands allowed and disposed of. In the RFU, you say both sides are represented as per orders passed earlier, comma, the TCR has been received. As notices have already been issued and the respondents have entered appearance, comma, let the matter be listed for hearing after 4 weeks.
Obliged, Lordship.
Item number 2.
Lordship, as per the last court order, order dated 14/7/2026, the respondent number 1 was given a last chance to file the affidavit. However, till date we have not received any of the affidavit.
Your Lordship, on behalf of the respondent number 1, I am yet to receive instructions. I have already sent them a reminder, but have not yet received till date.
No, you see, this is a perishable product. Broom is a kind of grass, is a perishable product. You are stopping transportation, but when it comes to filing of the affidavit, you don't do it.
Lordship, in this particular case, the main respondents will be the respondent number 2 and 3, which I do not represent. I'm only appearing on behalf of the DC, Longklai. And the DC is not the authority who determines the individual entitlement of the gardener.
The main authorities, where is the impugned order?
The impugned order is at page 25, my lords.
25.
25, my lords. So, this is the notification dated 6th of October 2025. So, the broom grass growers are directed to register their land, their farmland. So, if they don't register it, so all their products will come to the hands of the successful bidder. It will be considered as natural growth. This is the main grievance, my lords.
Who is this respondent number 4?
Respondent number 4 is, my lords, the successful bidder, private respondent. So the seal tender notice is at page 22, my lords.
Respondent number 4 is also not represented.
But
And page 24.
But how do you say that you are interested? What is the statement made here?
My lords, that the petitioners are gardeners. So, white notification dated 6th of October 2026, seal tender notice was invited. And then, as per Annex 2, that is at page 24, the respondent number 4 was chosen as successful bidder. So, on 6th of October 2025.
No, but your writ petition is defective. We are being misled by your prayer. You see, your grievance in one of the paragraphs is that you are a garden.
Yes.
And your garden registration has expired.
My lords, I have a land pass. So within my land pass, I cultivated this broom grass, my lords. So
I understand, but they say that you have to be registered.
Yes, yes. And then after registration, we have to apply for. We have to submit another
But you have
application
not. But you have not applied. Your registration has already been expired.
My lords, some of the gardeners got their registration, but
You don't say that clearly in your writ petition. You don't say that who has got registration, who has got not.
My lords,
You are 57 gardens, right?
Yes, my lords.
Come to your statement made in paragraph paragraph 5. You say that you approached, but they denied registration. You are not seeking an direction to renew your registration.
No, my lords, there is not at this time. Only on this 6th of October, the notification was issued. But my lords, due to the petitioners are living in the
You see, the
CNST
government wants
area.
you to be registered. What is difficulty in registering?
But my lords, we don't know this notification because the people are living in a far-flung area, village area. There is no proper electricity and no internet connection. That's why, so that the respondents number 2 and 3 did not circulate it to the village council, my lords. That is why we don't know that this notification, my lords. So, and then after that, when we got to know that, we approached the respondent number 2 and 3, but we were denied to registration. Because
But
of-
your prayer is not to allow your registration.
Yes, we were not allowed
Then
to registration because
that's not your prayer.
time has expired, my lords.
In your writ petition, there is no prayer
Uh,
to allow you to register. Without registration, we can't stay it.
So, my lords, the reason why we are challenging is that uh, this notification has been issued arbitrarily. Another.
We are not staying it. We are not staying it.
I am saying it, my lords.
You have not filed. You are not paying for renewal of your license. That notification of the page 22 is not under challenge. Six 10/2025. Okay, and the notification dated to sell the so and so, and the notification dated so and so, by memo number so and so, and office memorandum dated so and so, by so and notification number so and so, shall not be quashed. But you have to tell us what is wrong in this 6. You don't make a prayer for allowing you to continue with that without registration.
My lords, the main reason for challenging is that this notification was issued arbitrarily. So another plantation like teak and another crops, they were not directed to register. Only the government, CIDC government targeted only the broom grass growers, my lords.
You see, if you've been a genuine broom grower, grass grower, you should have by now, when you are filing a writ petition, you know that you have to be registered. You don't seek a registration with a
Yes, my
direction
lords.
that.
At the time before filing this writ petition, we have approached the respondent authorities to entry, my lords, but we were not allowed to register my land.
You are at the same place all throughout. You were not allowed.
Yes,
but
my
you are
lords.
not aggrieved by that. You have not come to court for the purpose of your registration.
But my lords,
You are happy with not registration.
so we don't have any other remedy, my lords,
No.
because we were not allowed to register because of the time has expired.
If you were not allowed to be registered,
Yes.
it will be a false statement because you have not made a prayer in this writ petition to allow you to register.
I agree with you, my lords. But that the season, the first season was, my lords.
You could have said that I was not aware of it. I got myself registered. Now let me participate, or let me sell my own broom. That is not your prayer.
Yes, my lord, I agree with you, my lords.
You make
But-
an amendment.
But my lords,
You-
before filing the writ petition, we don't have another remedy, my lords, because
amend your writ
the
petition.
first season was.
You see, we are not quashing this page 22 notification.
Correct.
If that goes, then nothing remains in your writ petition. You will be suffering more.
But my lord, when we were about to file the writ petition, my lords, so there was no time. The first season was about to start.
Sorry, that is not our lookout.
And then,
Whether you
and then
you had time,
the next season is also coming on November, my lords.
you registered it in the meantime.
But we were not allowed, my lords.
We can't help it. You're not passing any interim order when you are not registering it. That where is the requirement of registration?
DCCF, District Council Conservator of Forest, CIDC.
Where is the notification by which it has been said that you have to register it?
Notification dated 6th of October 2025.
No, that is only with respect to the tender notice that applications are invited
My lords,
in Silkava.
page 25, my lords.
I am there at page 25, Annexure 3.
So with the notice, with the approval of the Deputy Commissioner Longklai and Caretaker, CIDC, the Environment, Forest and Climate Change Department invites private gardeners who grow broom grass within CIDC area to register their gardens with the Forest Department.
No, sorry, we are not interested. We don't find any merit.
My lords, these are the poor farmers, my lords. Growing of broom grass is, my lords, this is their main source of living, my lords.
Why don't you amend your writ petition? We don't understand. You are being adamant.
My lords, if I may be given time to submit additional affidavit and prayer.
You see,
So,
the Supreme Court has passed an order in that case of what is the name? That Mehta, the environment case. There they have said that even the timber at a private land cannot be cut. There's what Mehta it is? MC Mehta. Therefore, the government has a right to say that you don't cut your the broom grass without being registered, because they are charging you a levy of rupees 4 per kg. Now, if you have any difficulty, then you'll have to say what the difficulty is for the purpose of challenging. You say that you applied for registration, it was not allowed. If you applied and you don't get a license, what will you do? You will come to court for the license.
my lords,
If you have the license, then we can entertain and then say that this, what you call, for the reasons you are assigning, this would be illegal. But how can we now quash this?
my lords, the reason behind this notification was issued registration, because my lords, that the seal tender notice was invited only for natural growth, and if the broom grass growers do not register their farmland, all their cultivated plants, broom grass, will go to the hands of seal tenderer. So that is the intention behind of this notification, my lords.
And your other argument doesn't carry any weight. You say that the notification was not served through the village council. Now, if can somebody come and say that, well, I am a citizen of India, I have not been circulated the Constitution of India, therefore I don't follow it. It was not circulated to me through my community, through my elders, through my deputy commissioner of my district. Therefore, I don't follow the Constitution. Can there be a presumption of no knowledge of law?
But my lords, the condition, their condition is very poor, my lords. That we far beyond than we can imagine, my lords. There is no proper electricity. No, in some villages there is no internet connection.
Same thing
So,
in your village. You can't have knowledge of your Constitution of India. You can't have knowledge of the Bharatiya Nyaya Samhita. Can you say that I will commit offense because I don't know about this law?
No, my lords, that is not what I am trying to say, my lords. So, my lords, the notification was issued on 6th of October 2025, and the collecting season starts on March. So there is a small gap of months between the notification and the collecting season, my lords. Let's see.
Just a
Since-
moment. Your name?
Yes, Balalshri.
Right, so-and-so learned counsel for the petitioner and so-and-so learned government advocate appearing for respondent number 1.
Yes, Your Lordship, one.
The petitioner has filed an affidavit of Dasti indicating that notice by Dasti mode has been duly served on respondent numbers 2 and 3 as well as on respondent number 4. However, none appears on call for the respondent numbers 2, 3 and 4. Next para. The case of the petitioner is that they own private land holding in which they cultivate broom grass. First off, it is submitted that the villages and landholding is situated in a very hostile location where there is no electricity, transport, etc. Full stop. The further case is that by a notice dated 6/10/2025, the district council conservator of forest issued a notice. By a notice, the district council of forest directed the private gardens who grow broom grass within Chakma Autonomous District Council area to register their garden with the forest department if they wish to collect or extract broom grass under the permit system. First of all, and further, the said authority required registration of the private gardens. First of all, it was further stated that the gardens that are not registered with the department will be considered natural and would fall under the seal tender holder, and the private landowners would not be able to extract or collect or dispose of the broom grass. And it was further provided that the last date of submission of registration form is 30/11/2025, after which and registration form received after the final submission deadline will be considered invalid. Full stop. Next, the learned counsel for the petitioner has submitted that the authorities have issued tenders so that the tenderers would be able to collect broom grass grown at their private land and to sell it at the prescribed rates. Full stop. It is next para. It is stated in the writ petition that the petitioners applied for. They came to know late about the requirement of registration, and by the time they applied for registration, the deadline was over and their gardens were not registered. First off, it is submitted that the extraction period for the broom grass is till March next year. March of every year. First off, accordingly, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed number 1, notification dated 6/10/2025 within bracket Annexure 3, Office Memorandum dated 26/11/2025, within bracket Annexure 4, and notification dated 27/1/2026, within bracket Annexure 5. These are at page 25, 26, and 27, because you'll have to give that memo number. Okay? This memo number you will also get in page 18, their prayer. Page 18, their prayer. Under memo number so and so, dated so and so. Next para. The learned government advocate has submitted that she is appealing for the state, but the concerned authorities are respondent number 2 and 3. Next para. On a consideration that the broom grass grown at the private land would be a property which is attached to earth, comma, the state, by virtue of Article 300, capital A of the Constitution of India, prohibits the state under Article is prohibited to deprive persons of the property save and except by authority of law. Full stop. Therefore, comma, the broom grass being a perishable product, cannot be allowed to be sold by way of to be confiscated by the respondent numbers 2 and 3 and sold through tender process, which would deprive the petitioners from getting benefit of their harvest of the broom grass which is grown. Full stop. The impugned notification dated 6/10/2025 does not disclose the lawful authority through which any act, rules, or notification in force by which the Chakma Autonomous Council derives power to confiscate broom grass and to regulate its sale by the owner of the broom grass. Stop. Therefore, comma, take into consideration the aforesaid consideration, taking account of the aforesaid considerations, comma, broom grass, comma, not being an illegal commodity which is banned or prohibited by any law in force, comma, the court is inclined to stay the operation of number 1, 2, 3, and these three. Annexure, page 25, 26, and 27. Stayed. Next paragraph. Resultantly, comma, the respondents are prohibited from interfering with the sale, transportation and sale of the broom grass grown by the private gardens of the petitioner. Next paragraph, the petitioners shall produce a certified copy of the order before the respondent numbers 2 and 3 to bring this order to the notice of the said authority so as to make this order effective on them. Next para. List after 2 weeks.
Deeply obliged. Item number 3.
My lord, in the process of filing an affidavit for this particular case, my lord, there was an introduction of new process in filing the affidavit, and that is the reason why, my lord, we have to make some corrections.
It's okay, your interim order is there, you can take your time.
Yes, my lord. So if it may be listed.
Both, all sides are represented on the prayer made by the learned counsel for the respondents. Week's time is further 1 week's time is granted.
Yes, my lord.
To the respondents to file their affidavit in opposition. Next para. Interim order passed earlier. Shall continue till the next date of listing. Next para. List on. After a week, give a date.
My lord, if it may be listed on 25th.
25th?
Yes, my lord.
Okay.
Obliged, my lord.
Obliged.
I'll have to rise to the members of the bar. I'm sorry, I'm unable to take up matters. I have a duty to perform.
My lord, the same prayer goes for the item number 4 to 7, my lord.
Okay. Court must take it. You adjourn it to? Adjourn to?
With the same prayer.
With the same prayer, my lord. Same prayer, my lord.
Okay, same.
Your Lordship, with regards to today's list, item number 12.
Just tell the courtmaster he'll manage these orders because I have to leave. There's a program at 3.
Your Lordship, if this can be fixed next week.
We'll do it. Just
yes,
take
Your
the
Lordship.
dates. Whatever dates the learned counsel are suggesting, please give those dates.
Obliged.
I'm sorry that there's a typing error, I am told, in the order. We'll have it listed tomorrow to have it corrected. I was informed that there was an error in the typing error. It is, in fact, it should have been, word should have been different. It should have been mutually.
Yes, my lord.
Yes.
I have mentioned that I have filed 2 writ petition unlisted. Yesterday I have filed that the case number also given as 114 and 115, 2026. Then
I
case
think,
may be listed tomorrow.
I think we allowed the mention.
Yes.
We allowed the mention. No, somebody made a prayer for upgrading a matter.
My apologies, my lord. For item number 14, my lord, there is an urgency in the matter, my lord, since the respondent number 1 is taking steps to withdraw the monies from the account line SBI, my lord.
Okay.
My senior is.
Can we take it up tomorrow?
If possible, my lord, they're taking its,
Because I have a
we've
duty
heard that
at
it's
3
in the
o'clock, that's
process.
why.
Yes,
We'll take it up tomorrow?
yes, my lord.
Okay. You say that the learned counsel, due to paucity of time, the matter could not be taken up today. Next part, the learned counsel for the appellant submit that there is urgency in the matter. Next part, list on, make it tomorrow. We'll get
Deeply
it tomorrow.
obliged, my lord.
I had forgotten, when I came down, I remembered that somebody made a prayer for upgrading. I'm sorry.